You're welcome back. In November last year, during the opening of the 2025 All Nigerian Judges Conference of the Superior Court, President Bola Tinubu highlighted the difficulties in accessing justice, delayed judgments, questionable conduct, and other issues militating against the dispensation of justice in Nigeria. In his words, and quote, "Justice must never be for sale, and the bench must never become a sanctuary for compromise. Corruption in any arm of government weakens the nation, but corruption in the judiciary destroys it at its core. These perceptions, whether wholly justified or not, cannot be ignored. The call upon us to reflect, to reform, and to restore," end of quote. Now, the question, however, arises: to what extent have the men and women of the Nigerian bench tried to internalize the president's words? With the political space getting busier than normal, how prepared are they to interpret the law in the overall interest of citizens? Legal practitioner and consultant Professor Yemi Akinseye-George joins us now to discuss reforms by the National Judicial Council, progress and impact. Good to have you with us, sir.
Thank you. Good afternoon.
Good afternoon. So recently, the National Judicial Council introduced a new policy guidelines that allows members of the public to have a say in the appointment of judges. Now, members of the public can now write to the council to object to a candidate being appointed a judge. So what has been the impact of this policy, you think?
Thank you. This singular policy decision by the NJC is a gigantic step in the right direction, and the legal profession deeply appreciates this endeavor by the National Judicial Council to restore dignity and quality in the appointment of judges by involving the members of the public. The legal profession and the civil society had for long advocated that the process of appointment of judges must guarantee quality and integrity. It is gratifying that the NJC, under the leadership of His Lordship, the Chief Justice of Nigeria, has taken a decisive step, by involving the public, subjecting the process to public participation, by asking the members of the public to make their views known, to comment on candidates, and I realized that many candidates were found were dropped from the list. In the process of sifting led to the reduction of the list of appointable candidates. And I think it's a step in the right direction, and it is going to significantly ensure that only candidates of character and integrity and of learning, those who really merit the appointment, will be appointed to the bench.
Now, Professor, but it seems despite this innovation, many people are still not satisfied with some of the judicial appointment. What else do you think needs to be fixed?
It is not possible to please everybody. What is important is that the objective, the standard set, the guidelines that were put in place by the NJC were applied objectively. And those who did not meet up to the standards have been dropped. And those who met the standards have been recommended to the president. Unlike in the past, where, names just surface from everywhere. Politicians, all kinds of, in fact, all kinds of lists, but that's no longer the case. The NJC has taken charge of the position, of the process of appointment of judges. This is beginning to build confidence in the appointment process. And once we get the appointment process right, once the right people are appointed to the bench, it's going to significantly restore public confidence in the justice system and in the judiciary. Of course, you can't find a system that will please everybody. What's important is that the standards, the criteria set, has been met, and once those standards have been complied with, we begin to see a restoration of the dignity and the confidence of not only of the members of the legal profession, but of the members of the public in the judiciary. So right appointments are needed to guarantee, proper dispensation or administration of justice.
Indeed, Professor. Now, still talking about the NJC, it appears to be known largely for punishing judges. So what other roles does the council perform?
Oh, the NJC performs a coordinating role for the judiciary, not only at the federal level, but also at the state level. Whereas at the state level, there is what is called the State Judicial Service Commission. The State Judicial Service Commission that makes recommendations to the NJC. But we have found that there's a lot of political interference with the work of State Judicial Service Commissions. So the NJC has a role to play to ensure that appointments at the state level are also brought within these national parameters of quality and standard. So although it's the NJC is a national body, but it has jurisdiction to make sure that only excellent candidates, only candidates who meet these standards eventually get appointed. So when recommendations come in from the FGS, from the State Judicial Service Commission, which do not meet the standard, NJC, I believe, can still say that, no, we are not going to proceed with this process because the standards have not been met. So the NJC is a kind of a clearing forum. It's the regulatory platform which ensures that all courts, across the federation, state level courts, federal courts, all meet the standards of appointment of judges. So it is not just about discipline of judges. It's not about a dismissal or, the NJC also takes care of promotion, quality of, service. Quality of service. They ensure that judges perform their function very well. They also ensure that, infrastructure, relevant infrastructure and working environment of courts are adequate. Of course, the NJC cannot dictate to the states, but they have a responsibility to set the standard. Once they set the standard, and states that do not meet those standards can be named, and they're told that you have not met the standard that is required. I believe the NJC will do more of that standard setting and standard implementation, to ensure that judiciary is not only taken care of at the federal level, but that at the states, the courts are also well compensated, well treated, and provided decent and reasonable working environment to be able to do their job properly.
Now, Professor, whereas the NJC keeps sanctioning judges, what happens to lawyers who lure judges into a corrupt act? It seems the NJC does not have power to sanction these legal practitioners. What should be done to such lawyers?
Oh, thank you. The NJC primarily disciplines and, takes care of matters concerning judges. To that extent, you are right. But the NJC has an indirect power to deal with lawyers, for example, lawyers who write frivolous petitions against judges. And how does the NJC do that? The NJC can refer such cases to disciplinary bodies of the bar, of the legal profession. We have the Legal Practitioners Privileges Committee, for example, where a senior advocate or a senior lawyer is found to have violated the ethics of the profession, have violated some of the principles of submission of petition to the NJC or by writing frivolous petitions. NJC can refer such senior lawyers to the LPPC because the rank of senior advocate is a privilege. So the LPPC, can take appropriate action against such senior lawyers. And where such lawyers are not senior advocates, the NJC can equally refer their cases to the Legal Practitioners Disciplinary Committee. So the NJC is not powerless, although the exercise of power to discipline lawyers is indirect, in the form of referral. So where lawyers are found to have written frivolous petitions or conducted themselves in a manner that the NJC finds offensive to the judicial process, So the NJC can also take action against lawyers, but such actions are only taken through the bodies, either the LPPC or the LPDC.
Indeed, Professor. Now, some courts across the country are in a state of disrepair. You know, everywhere you go, we see courtrooms overflowing with water. The court is actually sitting. So how do we improve infrastructure in our courts, you think?
Thank you so much. I'm aware at the moment that some delegations or teams of inspectors from the NJC, have gone or are going around the country to inspect the infrastructure of courts, and that's a step in the right direction. Even though the NJC may not be able to, provide the resources for the states, for capital projects, development of court infrastructure, but the NJC is beginning to set standards. This is the minimum we require of any decent court. You go around the country, you see some courts looking I don't even know what to call it. You can't call them courts. They are not ventilated. There are no fans. There are no air conditioners. There are no gadgets, and you call them courts. Some of those are even supposed to be high courts. I have known of situations where lawyers are unable to perform their jobs in courts because of lack of ventilation. So it is important that the NJC has begun not merely to say that these are the standards we require. The courts must be properly fitted with facilities, gadgets, and so on. It is not sufficient to set those standards. We need to enforce those standards by coming out with a list, by a kind of a ranking system or a rating system, whereby all the states in the federation are made to go through that rating system, so that by the end of the day, annually or bi-yearly, the report is published in terms of states that are doing well, states that are not doing so well, states that are below standards in terms of provision of decent working environment for the judges, for the litigants who are appearing in court, for practitioners, good furniture, good recording gadgets, good communication gadgets in the courts. So I think the decision taken by the NJC to send their inspectors to inspect the courts across the country, and I will say that this should not be limited to high courts. It should not be limited to high courts. We should also look at the magistrates, because the majority of cases are conducted in the magistrates. So if the high courts are well fitted and the magistrate courts are not well fitted, and that's where most Nigerians have their first experience of the judicial system, so it's going to reflect very badly on the entire judicial system. And even though we're a federal country, it seems that our constitution has given us a unitary judicial system. We have one Supreme Court for the entire country. We have a single court of appeal for the entire country. We have a single federal high court for the entire country. And we have an NJC that overlooks all the courts in the federation. So NJC has begun to perform that standard-setting role. But as I said, it's not sufficient to set the standards. We must name those states that are compliant with the standards. We must also name those that are not compliant with the standards, so that the governors or the people in charge of those states will know that they're the ones that are not complying with the standards set by the NJC with respect to provision of decent and standard facilities for the courts in their states.
Now, Professor, I'd like to take you back to the issue of sanctioning erring judges. How transparent and effective is the NJC's disciplinary process for erring judicial officers? I'm wondering if there's a perception that judicial accountability is selective or influenced by politics.
To a very large extent, the perception of selectivity was quite rife. I said was. But since the commencement of the current judicial administration of Honorable Justice Kekere Ekun, Chief Justice of Nigeria, judges, lawyers who have followed the process of discipline of judges, are predominantly of the view that the system appears to be objective, appears to be scientific, and to follow due process. Giving everybody a chance. Petitioners are given a chance. Those whose petitions are frivolous are informed. And when petitions are written, judges against whom petitions are written are given the opportunity to comment on such petitions. If I was reading a recent report where a judge who used foul language in responding to a petition was sanctioned by the NJC. So the process has become very fair. The process has become very objective. The process has become very scientific. The process has become, in fact, commendable. But the challenge is, are we going to sustain it? I believe it should be sustained. And the way we can sustain it is for the members of the public, for civil society, for the legal practitioners to continue to comment, to continue to show interest in what goes on in the NJC. The leadership has shown commitment. We need to support them. We need to appreciate even those efforts that are being made to restore the integrity of the disciplinary process, not just of the appointing process, but also of the disciplinary process. I think the process has begun, and in a few years, we should be able to restore, that position of respect, honor, and dignity that we lost through, maladministration of the judicial system in the past, which process has begun to be corrected and placed on the right footing now.
Indeed, Professor. Now, earlier on you talked about the standard setting, of course, regulatory functions of the NJC, but how legally binding are the reforms being pushed forward by the body on the judiciary, as it were? Do they have to go through a higher body, or is just once they get this done, it's effective?
The NJC is very powerful. The NJC is very influential. So it may not be a matter of legal bindingness or something like that, But when the NJC sets standards, I think those standards are usually respected by the courts in the states. The challenge is when the executive at the state level, the executive arm of government, does not allow the state judicial service commissions to perform their roles, filling up those commissions with their lackeys and people who may not be qualified for such positions. NJC cannot force them as to who they are going to appoint to their commissions. But when the standard has been set, and where the standard is not clear, the NJC will say, these are the kind of people we expect to be on the commission. So that the quality of the outputs of that commission will be reasonable. The output will be reasonable and acceptable. So it may not be legally binding, but it's morally binding. It's morally binding, and in a way, where the NJC insists that things have not been done properly, I believe that the NJC has the power to do so. Even though it is always, in most cases, it's not a matter of law, but it's a matter of precedent, a matter of respect for convention, a matter of respect for constitutional authority. And in our profession, we place so much respect, we place so much preference on respect for constituted authority. So the Chief Justice of Nigeria is very powerful. And as the chairman of the NJC, decisions and standards that are set by the NJC must be respected by state judicial authorities. And where some governors have pulled recalcitrance, we have found in many cases there are governors who think that they can disrespect the NJC. I think they do so at their own peril. Because ultimately, these same governors will come back to the courts to seek one favor or the other. So it is important that all the arms of government should respect each other. The executive should respect the legislature should respect, and the executive should respect the judiciary. It is by giving mutual respect, not necessarily saying that we are enforcing the law and all of that. But when we give respect to other arms of government, then we too will be given that respect. So respect begets respect. And human beings have to apply the law. The law can never apply itself. So when we allow the spirit of the law to prevail, regardless of our selfish motives or personal interest, then we will have a decent society, and that's where the judiciary comes in. That's where the judiciary comes in to put the political branches in their place, to make sure that the political branches do the right thing. And once the political branches know that the judiciary will not allow any wrongdoing to stand. When the political branches know that the due process will be maintained by the judiciary, I think that will be the beginning of our society moving in the right direction and our democracy getting consolidated. You know, a situation where judges cannot think that, politicians do not think that judges are their beck and call. They can just call a judge and get any order that they want. You know, we are gradually beginning to see a situation where respect for the judiciary is beginning. And once the leadership takes a stand, once the leadership of the judiciary takes a stand, this is where we stand as a judiciary. I think the politicians will understand that these are not people you toy with. These are not people you play with. You know, that will not come cheap. A lot of, you know, sacrifice has to be made, but the moral authority of the judiciary is what gives the judiciary its power, the moral authority, not necessarily, you know, strict legal authority. When that moral authority is recognized and appreciated by all and sundry, people will be careful in toying with the authority and the power of the judiciary. So that's how it operates in a democratic system.
Legal practitioner and consultant, Professor Yemi Akinseye-George, thank you so much for joining us on Newsday.